we are outside St Paul's on a fine July morning. There's been an impromptu wedding going on, stroke photo shoot. Hello. Well, today I'm sat in the Savile Club's monument, this repository of volumes that have been written by members of the club, which exist for members to come and have a look at and have a read. I'm not going to read any today. Instead, what I want to do is tell you about the case of IRC and Broadway Cottages. And the citation for that case is 1955, square brackets, Chancery at page 20. This is an interesting case for objects, and in particular it provides us with a test to think about how we might, as trustees for example, make distributions to particular objects. This case is also interesting because the potential objects that we're talking about, the settlement was made by Alan Timpson. He settled property, the subject matter was £80,000 on trust for his wife, who was Ethel Beatrice Timpson, and other specified people who were listed in a schedule. And it's those people, those objects, that we need to consider, because the term of art that is deployed in that schedule is employed by, and it's in relation to certain companies. So distributions, or all other persons employed by the settler, the wife of the settler, and a number of other characters, including limited companies with which Timpson had been associated with. So the question before the court is, how does one define in a fixed trust all potential objects? And if one can't define all of those objects, ergo all of those people employed by the settler, etc., in the schedule, does that mean the trust is void for lack of certainty, i.e. we can't be certain who all the employees are of these given people, and therefore we can't make a distribution? So at first instance, the case goes before Mr. Justice Wynne Parry, who held that the trusts of income were void for uncertainty. So the employees lose out. It's obviously appealed and goes up before Singleton, Jenkins and Hodson in the Court of Appeal, and it's Lord Justice Jenkins' judgment that you should concentrate on, and in particular the fixed list ideas enunciated by Lord Justice Jenkins, for example, in that judgment, or that portion of the judgment. And in particular, for example, where he talks about the idea that there can be no division in equal shares amongst a class of persons unless all the members of the class are known. That's obviously a rigorous test, particularly if you've got lots of employees, and obviously it may lead to uncertainty because at any given time you can't draw up a complete list, perhaps, to enable you to pro rata distribute that income amongst that specified certain group, namely the employees. So Jenkins and his brethren say that that clause I've referred to is just too wide, that it's uncertain. The beneficiaries for the purposes of the settlement comprise an aggregate of objects which is incapable of ascertainment, in the sense it would be impossible at any given time to achieve a complete and exhaustive enumeration of all the persons then qualified for inclusion in the class of beneficiaries under the terms of the schedule. Relying on cases like Morris and Bishop of Durham, then the Lord Justices say that there is uncertainty here. The subject matter reverts pursuant to a resulting trust back to the estate of the settler in terms of the idea of equity abhorring a vacuum, so it doesn't languish, it does move, does that value. In summary, we might say then that the judgment in IRC and Broadway Cottages is a rigorous one. It's one that is addressed, as we'll see in due course, in McPhail, Dalton and Gulbenkian and Rebader number 2 cases that we're going to talk about in other videos. But for a fixed trust, we might say that having to have a complete list is onerous and can tend towards uncertainty if terms like employee or perhaps relatives or even friends, as we might mull on, are mentioned. So that's IRC and Broadway Cottages in brief outline. From here, the monument of the Savile Club, and I bid you goodbye. Goodbye.